Welcome, everyone. Thank you so much for joining us here today for the CIL seminar on investment protection and regulatory reform for climate change in Asia. This is the first in in the seminar series on climate change and investment. I'm Rayla Puno, Research Assistant at the NUS Center for International Law, and I will be your MC for this seminar. Today, we are fortunate to hear from 5 distinguished panelists, after which we will have a discussion where there will be an opportunity for the audience to ask questions through the chat box. May I now please invite Dr. Nilofer Aral, Director of the NUS Center for International Law, for the welcome remarks.
Thank you so much, dear Rayla, and greetings to all of you from Singapore. As Director of the Center for International Law at the National University of Singapore, it is really my great pleasure to welcome you to what is the first of 6 seminars on climate change and investment. In today's seminar, we will begin by looking at the issues raised at the intersection of investment protection and regulatory reform to address climate change in Asia. Our panelists today include some of the most preeminent scholars in this field, and I have no doubt that you'll have a very engaging and productive discussion. Now, our seminar convenes just as COP27 has concluded, and just as states have reaffirmed their commitment under the Paris Agreement to limit global temperature rise to 1.5 degrees Celsius above pre-industrial levels. Now, while this affirmation of the Paris target is of course positive, we know from reports, alas, that the window of opportunity to succeed in this goal is rapidly closing. In fact, despite state pledges and initiatives over the past 6 years that the Paris Agreement has been enforced, the scientific indicators show that under current conditions, we are on a trajectory of a rise of 8 degrees Celsius by the end of the century, almost twice the Paris target. The Sharm el-Sheikh implementation plan that was decided also at COP27 highlights the enormous financial costs that a global transformation to a low-carbon economy, the net zero pathway, will entail in terms of both climate change mitigation and climate change adaptation. Covering these costs presents a challenge of unprecedented scope and will require swift and comprehensive transformation of global financial flows, engaging governments, the financial sector, private and public investors, and other actors. As a result, the proper alignment of the international legal framework for investment is of critical importance to address the existential threat by climate change, and especially so in Asia, where some 50% of global totals of emissions are produced here. So let me now end, because I think I should let the panel start by thanking all our panelists and my colleagues here at the Center for International Law for organizing this series and for their efforts and a contribution to bring us together, and especially, again, a special thanks to the panelists. So I look forward to the discussion and actually learning more about this absolutely important and critical issue. All right, Rayla, over to you.
Thank you so much, Nilofer. I will now hand over the floor to our moderator for today and our series convener, Jansen Kalamita, Head of the Investment Law and Policy Team of the NUS Center for International Law and Research Associate Professor with the NUS Faculty of Law.
Thank you very much, Rayla, and thank you, Nilofer, for the kind introduction. As Nilofer said, this is the first in a series being organized by the Center for International Law addressing climate change and investment. In 2015, under Article 2.1c of the Paris Agreement, 196 states committed to strengthening the global response to climate change by, quote, making financial flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. As has been said, it's hard to overstate the magnitude of this kind of ambition, which essentially calls for the wholesale realignment of state economic regulation and private sector practices around the globe, in order to limit financial flows to carbon-intensive activities and redirect those flows to Paris-aligned ones, namely those which promote climate change mitigation and climate change adaptation. Now, in this series, we read the reference to financial flows in Article 21C very broadly, as encompassing investment both from the private sector and from state-owned entities. And looking at the challenges posed by climate change and the magnitude of changes required for states to achieve their individual commitments and collectively limit global warming to 1.5 degrees above pre-industrial levels, there seems to be no question that investment financing is going to play a critical role. In fact, to throw a few numbers into the mix, according to the IMF, developing economies will need to invest at least $1 trillion in energy infrastructure by 2030, and between 3 to 6 trillion across all sectors per year by 2050 to mitigate climate change. Obviously, these are daunting, if not mind-boggling numbers. Much of the discussion in academic and policy circles, especially among international economic lawyers, focuses on investment protection treaties and the implications of substantive investment protection on the ability of states to adopt climate change-related measures. And the risk too, states may face investment claims or claims by investors and possibly steep arbitral awards. And that, of course, is where we start our series today, looking at the scope of protections in the current investment treaty regime, the risks they pose for states, and the possibility for effective and timely reform. But while the issues raised by investment protection treaties and investor-state arbitration are important, this series takes a much broader view of the international legal issues raised by the challenge of climate change and the commitment contained in Article 21C. As international lawyers, and especially those of us who are international lawyers focused on the international legal framework for investment, Article 21C really challenges us to get outside of our comfort zones and to look at the realignment of investment flows in the round. And what this means is that we can't simply focus on ways to ensure that reasonable regulations are not thwarted by investor claims or threats of claims, but instead, we need to take a broader view of the multitude of international legal regimes that play a role throughout the investment lifecycle. In other words, we need to consider the roles of international regimes addressing, for example, the facilitation of Paris-aligned investment, the impact of trade disciplines on investment flows, the establishment of harmonized or internationalized guidelines and standards applicable to non-state actors, whether that's with respect to finance, insurance, securities regulation, or corporate governance, to name just a few. These are areas that are frequently overlooked in discussions that proceed under the banner of international investment law, and especially those which focus on international investment treaties. In this series also, we take a decided focus on Asia, especially the states parties to the Regional Comprehensive Economic Partnership, or RCEP, a vast free trade agreement among the 10 ASEAN member states and 5 of their FTA partners, Australia, China, Japan, Korea, and New Zealand. Further, we include India, which, although not a party to the RCEP agreement, is ASEAN's other main FTA partner and soon to be the world's most populous nation. Why do we take this focus? Because, as Nilofer noted in her open remarks, without Asia, there is no global solution to the climate change crisis. And because, moreover, compared to regulatory and treaty reform discussions in Europe and North America, the situation in Asia is often overlooked and, frankly, is less further along than in those regions. And so as a result, with that in mind, throughout this series, in addition to exploring the state of play in Asian countries, institutions, economic blocs, we're also going to be asking broadly what role states in Asia can play in creating global solutions, and importantly, whether states in Asia are willing to lead in this space. So that then is the ambition of the series. In today's seminar, we begin with, as I mentioned, the subject on which there's already a significant amount of discussion, whether in UNCTAD or the OECD or elsewhere, and that is the risks posed by investment treaties with respect to state regulation for climate change mitigation and adaptation. And when we think about the issues here, it bears keeping in mind that we're concerned with essentially three classes of possible claim. First, claims by fossil fuel investors with respect to state regulations to phase out, limit, or terminate investor activities. And here, by way of example, we can point to the recent award in Rockhopper versus Italy, in which the investor, Rockhopper, was awarded more than 250 million euro on a claim brought under the Energy Charter Treaty, following Italy's institution of an offshore drilling ban. What's notable in that case in particular is that Rockhopper's investment had never even become operational, and at the time of the ban, Rockhopper's sunk costs amounted to just 29 million euro. Second class of claims for us to keep in mind are claims by investors not in the energy sector, but in industries with high carbon footprints. And again, here we can see claims arising with respect to changes in state regulations to require these industries to transition to low carbon operations or even to terminate their operations. And then finally, we need to consider claims with respect to investments in aid of climate change mitigation and adaptation. For example, the production of clean, renewable energy. And here, as is well known, especially the Energy Charter Treaty raises the specter of significant claims being brought against states, as claims against European states in particular currently total some 82, arising out of the decisions by countries in the EU to terminate or modify various incentive schemes designed to promote investment in solar power. Now, in one sense, there's nothing particularly novel about these claims, especially the legal bases upon which investors are making them. Fair and equitable treatment, indirect expropriation, legitimate expectations, and so forth. Investors both within and without the energy sector have been bringing claims against states on these theories for more than 20 years, often based upon regulations directed towards environmental concerns. But in a more important sense, given the existential and global character of the threat posed by climate change, the situation in which the investment protection regime finds itself is unprecedented, both in terms of the short time frame within which states need to adopt regulations designed to limit financial flows through carbon-intensive activities, and with respect to the scope of the realignment called for, the potential claims that states may face from investors may just be unlike anything the investment treaty regime has seen before. Of course, states face these risks under treaties that they have signed, under treaties that they have negotiated, under treaties that they have written, but at least as importantly, pursuant to approaches taken by arbitral tribunals in interpreting and applying those often skeletal texts. In some more recent treaties, of course, states have begun to indicate directly in their texts that regulations designed for environmental protection deserve special consideration, and sometimes even refer to climate change itself. In principle, states have adopted this new language to shape or limit the exercise of interpretive discretion by arbitral tribunals and to indicate their intention that when investors bring claims concerning environmental regulations, the state's actions should be treated with a high degree of deference. But even so, significant questions, I think, remain as to whether these provisions in newer treaties will actually be effective in shielding climate change measures from successful claims by investors. The claims brought under these newer treaties are relatively few to this point, in no small part, at least, because these newer treaties fail to replace the older treaties on which investors would prefer to bring their claims. But anecdotally, at least, there are indications that things like environmental carve-out provisions and general exception provisions may not provide the protection that states had hoped. And here we can look at the 2021 award in Eco-Oro Minerals versus Colombia, in which the environmental carve-out clause was interpreted as a matter of law not to protect the state from an award for compensation for the environmental measures that it took. And also to the 2017 award in Bear Creek Mining versus Peru, in which the treaty's general exceptions clause was interpreted as actually limiting the state's ability to rely on its customary international law power to regulate for the public good. Nevertheless, even though there are questions about the effectiveness of this new kind of language in shielding states, it bears noting that within Asia and within ASEAN in particular, this kind of language actually remains a rarity. In connection with this seminar and with our seminar in January, in which we'll look at the calculation of compensation in investor state claims involving climate change, we've begun a stock taking of ASEAN's treaties, comprising those treaties among the individual ASEAN states, treaties between ASEAN states and third countries, and treaties concluded by ASEAN collectively as a community of states, such as its treaties with its FTA partners in RCEP. And while our numbers are early, the initial indications are that across the nearly 300 treaties we've reviewed so far, a mere 11% contain any reference to environmental protection at all, and that these vary widely from general preambular references to the inclusion in indirect expropriation annexes to full-fledged chapters on environment, as we see in the recently upgraded China-Singapore FTA. Beyond that, less than 1% of these treaties, namely 2 FTAs involving Chile, Indonesia, and Vietnam, make any reference to climate change itself. We're continuing this stock taking, and we'll be releasing a detailed report in January. It's time for me to stop talking now and to introduce our speakers and to turn things over to them. And with us today are Professor Anatol Butt, Professor Yuka Fukunaga, Professor Lauge Poulsen, my NUS colleague, Professor Sonoraja, and Professor Ying Zhu. As Nilofer mentioned, they are all preeminent scholars in their field, and we're fortunate and grateful to have them with us today. I will not take the time to go through the extensive CVs of our speakers. I'd ask Raela to simply post the link in the chat box for you to consult if you so like. But let me turn things over directly first to Professor Poulsen, who will begin by telling us about the work that's ongoing in the OECD and how both developed and developing Asian states can work within that process, while perhaps at the same time pursuing Asia-based processes of their own. So, over to you, Lauge.
Thank you, Jansen. I just want to confirm, first of all, whether you can hear me. Yes, good, because I had to set up my phone here in my living room because the power went out in North London about an hour ago. Whether there is a comment on that with respect to the climate change, I'm not sure. Apart from, I guess, we all need to invest in critical energy infrastructure in order to heat our houses and meet the net zero challenge. I had a series of slides I want to show. I'm sorry I can't provide them. I'm happy to send them to those who've called in today. And thank you, Jansen, for inviting me and for inviting the OECD to speak here at your series. We think this initiative is extremely important. As you mentioned, Asia is a crucial region in this challenge, and I think your initiative takes up the mantle at a very opportune time. So thank you so much for inviting me. I should mention I'm here in my capacity as chair of the OECD work program on the future of investment treaties, where in the track that I am chairing, we are focusing on the alignment of investment treaties with the Paris Agreement and net zero, and it's in that capacity I'm here today. What I'm going to do is I'm just going to very briefly outline what we're doing in the OECD, the discussions we've had so far, and where those discussions are going over the next year or so. As background, the OECD's initiative on climate change and investment treaties is the first sustained multilateral initiative on this topic. As was mentioned in the introductory remarks, there has been a range of initiatives, particularly over the last year, from a range of actors. But what we've done in the OECD over the last little bit more than a year is sort of really the first sustained engagement on this from an international organization. What we are doing is that we are asking ourselves, we are asking stakeholders, we are asking experts, we are asking governments, what investment treaties that are aligned with the Paris Agreement, that are aligned with net zero objectives would look like. That's the exam question we're trying to address. And this is a government-led initiative. So we have almost 100 states that are formally part of the process. But we also include a wide range of stakeholders and a wide range of experts in our meetings and in our other activities. So this year we ran, for instance, a public consultation for experts to feed into the process, to provide ideas on what Paris alignment might look like from the perspective of the investment treaty regime. And we also include experts and stakeholders in our meetings which are open and that are transparent. So we provide summaries of what happens in those meetings on social media, and there's a dedicated web page as well where you can find more information. And another thing that we're trying to do with this process is to bring in a wide range of inputs from different professional fields and different sources of expertise. So over the last year, we have brought in experts from climate change law, climate change policy, from trade policy communities, and particularly from the area of finance, so as to broaden the conversation and make sure that the learning process that we are undertaking at the OECD level is not just based on views and sources of expertise within the investment law bubble, as it were. And so far, we've had sort of 4 themes that's come out of our discussions in our meetings and in our treaty conference last April. And in a sense, Jansen sort of teed me up perfectly for this talk, because he sort of, in a sense, I think, walked you through a number of those themes already. And the first one is that what we've learned from our colleagues in other or related policy fields is that we've had significant efforts in the area of trade, and particularly in the area of finance, to align with Paris and net zero objectives. So our trade policy colleagues, our colleagues working on the international financial architecture, have been at it for a while, and I think it's probably fair to say that the investment treaty community might have come a little bit late to this challenge. And that in itself is one of the themes that we have sort of been reflecting upon, given that market actors are looking for clear and unambiguous signals from governments if they are to make their investments in line with Paris and climate change objectives. In other words, a credible climate policy for any government, whatever that climate policy may be, must be consistent. And I think that's an important lesson for the investment treaty community, first of all, that we are reflecting on in the OECD process: consistency. The second theme in our discussions is that while, as Jansen noted, there have indeed been some efforts, particularly over the last year and a half, to try and address the climate challenge in investment treaty policies. Those efforts have focused largely on removing constraints or treaty constraints on climate regulation at home. So removing possible exposures to liability for climate change measures. Now that's important. The policy space challenge is important here, and it's something we're focusing also at the OECD, and I can see in your seminar series as well, this is an important theme. One of the things where the policy space challenge, or generally the climate change challenge in the context of investment treaties, is a bit unique, is that it matters as much whether you have policy flexibility at home as it does for whether states have policy flexibilities abroad. In other words, if the reforms you're undertaking in your investment treaty regime are genuinely about climate change objectives, well, then one should be equally concerned with possible constraints on climate change measures abroad as one is at home. In other words, solutions to this issue must be global, because a ton of carbon on the other side of the planet has the same effect on the climate as a ton of carbon that's emitted from home. In climate change terms, they are equivalent. So if an investment treaty reform package is intended to address a climate change problem, well, then it has to think globally and not just think about policy space or climate change or Paris alignment at home. That's a second. Sorry, I think we have some visitors on the line here. The third theme is that we have heard from experts over the last year how the climate challenge might be different, might be unique in an investment treaty context, not just because of the scale and gravity of the challenge, but also because of the urgency of the responses that are needed. Reforms today will have a far greater impact on the climate than reforms 5, 10, 15 years down the line. Now, again, that is an important lesson or insight, I think, for the investment treaty community as well, because provided that governments think that treaty reforms are needed, and but provided that treaty reforms are needed, well, then to the extent that the aim is to address the climate challenge, well, then those reforms cannot wait. And also, they cannot be fraught with uncertainty. Jansen alluded to this as well in his initial remarks, that we have a range of possible responses in our toolbox as investment treaty policymakers that may potentially, in theory, be helpful to align investment treaties with Paris, but some of our usual suspects are somewhat uncertain reform efforts. And Jansen alluded to exceptions, but there are other sorts of approaches to reform as well that are either take a very long time. Reform tends to take a very long time in this regime, but also where the possible impacts are slightly uncertain, particularly if they are to be applied, interpreted by arbitral tribunals independent from governments. The final theme that we have discussed in an OECD context is the role of the Paris Agreement's Article 2.1c. And I was delighted to hear in the introductory remarks from Janssen and in the materials that were shared about this seminar series at NUS that this is also a core theme here. So just to remind everyone of what this obligation entails. So Janssen already mentioned it. So the Article 2.1c of the Paris Agreement commits states to make finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. So what does this mean for the investment treaty regime, this commitment that states have made in the Paris Agreement? This is the core, this is a core question that we are addressing in the OECD process. Now, in related regimes, this provision has resulted in quite significant activity. So it's resulted in significant private initiatives, particularly from banks and from insurers, looking at whether and to what extent their portfolios, whether portfolios are based at home or abroad, are in fact aligned with climate objectives. But we've also had initiatives from regulators, central banks. We've had initiatives from state-backed investment insurers, political risk insurance. Again, looking at whether the support that they are providing to foreign firms or foreign projects is aligned with Article 2.1c or with climate change objectives. Now, the core thing, and Janssen alluded to this already, the core approach that Article 2.1c prompts us to sort of to consider in the context of investment policy is to look at which sorts of assets, which sorts of projects, which sorts of investors that are being supported or being insured, not so much the types of risks that are being insured against. So what we usually refer to in this regime as sort of the policy space, right? Article 2.1c prompts us to think about the nature of the assets and activities that regulatory treaty instruments are supporting. Now, what does that mean for investment treaties? Well, we're sort of trying to work that out together with experts and governments. But first of all, it's important to remind ourselves that 2.1c and the Paris Agreement in general is an agreement that was entered into by governments. So we have had a lot of activity from banks, insurers. Some of that has not worked as intended. I think we can all agree. But even so, it was not banks and insurers that made these commitments. It was governments that made this commitment. Secondly, and again, you can have a look at some of the background materials developed by the OECD on this, that's available on our website. It is reasonable to conceptualize investment treaties and the support they provide as functionally equivalent to political risk insurance in many respects. Now, that's important because what political risk insurance does is provides essentially a type of support, some would say a subsidy, but at least a type of support to make investors better off than they would have otherwise been. And in the context of investment insurance, as I mentioned, we've had a number of initiatives thinking about whether that support is aligned with Paris when, for instance, it goes to fossil fuel investments. And finally, when we think about what 2.1c might imply for investment treaties, what the sort of the challenge of aligning portfolios might imply for investment treaties, well, there's just a final basic observation, that is that this is about finance flows. That's what the Paris Agreement is talking about, what Janssen also mentioned. And obviously, the investment treaty regime covers finance flows, including finance flows that are used for coal and for other fossil fuel investments. So what those sorts of observations entail for investment treaty policies is what we are considering in an OECD context. And Our next steps over the next year is, first of all, to learn from governments themselves. We have shared a survey to governments. This is the first large-scale climate survey related to investment treaties, and governments will feed back to the OECD in early in the new year in terms of the initiatives that they have begun or they're contemplating to align their investment treaty programs with climate objectives. All the questions in that survey, and they cover the gamut of issues that are in play here, are available on our website as a source of inspiration, including for those of you on the call here, experts, stakeholders. You're all invited to go have a look. It deals with market access issues, investment facilitation, investment protection standards. It deals with implementation issues, dispute settlement, coverage and scope, so forth. And we will, after learning from government inputs from this survey early in the new year, then initiate another major treaty conference on climate change and investment treaties in April. You are all invited. This is going to be a hybrid format, so we will have some people in the room, but you're also able to call in. And this will be on the 11th of April of 2023. So we look forward to continuing the discussion. And once again, congratulations to NUS for initiating this very important initiative.
Thanks very much, Lauge. Thank you very much for the overview of the work that OECD has begun and continues to do, and the many different inputs that are going into that work, and the importance of multilateral solutions and the pressure of time that states and the rest of us face in terms of finding those solutions and implementing them. At the same time as we look for multilateral solutions, we also note that there are particular investment treaty regimes, such as the Energy Charter Treaty, which have their own peculiarities and play their own particularly unique and important roles in our discussion, and particularly with respect to climate change. And that leads me to pass things along to our next speaker, Professor Yuka Fukunaga. Professor Fukunaga, let me, without further ado, in the interest of time, turn things over to you. Thank you.
Thank you very much for the invitation to this webinar. I enjoyed the previous speakers very much, so hopefully I'll add some different perspective to the discussion. Let me share my screen. Can you see my screen?
Not yet.
Not yet?
Yes, I can see it.
Okay. So I'm going to speak about the Energy Charter Treaty, and especially I'll focus on the divide between Europe and Japan. And here is the structure of my intervention. I start with a very brief explanation of the ECT modernization. As I said, there is a huge gap between Japan's position and the EU's position. So I'll highlight this divide, and then I'll move on to explain the background and the rationale, or perhaps a lack of rationale, for Japan's position in the ECT modernization process. And I'll briefly try to predict. It's very difficult to predict, actually, but I'll try to predict what happens in the future as my conclusion. So the modernization process, as I said, there is a huge divide between Japan and the EU. And that divide started from the very beginning when the modernization process started in 2017. And for the EU, the objective of the modernization is to facilitate sustainable energy investment. And also the objective is to balance the high-level investment protection with the contracting parties' right to regulate energy markets. At the same time, the EU seeks to ensure that the multilateral investment court that the EU is proposing would apply to the ECT. But on the other hand, Japan believes that it is not necessary to amend the current ECT provisions. So throughout the process, Japan opposes almost every single proposal made by the EU. But despite the huge disagreement between Japan and the EU, the contracting parties, including Japan and the EU, successfully reached an agreement in principle in June this year. And I think it's fair to say that the agreement in principle substantially reflect the EU's position, not to the full extent, but to a reasonable extent, it reflects the EU's position, I think. For example, the coverage. The parties agreed to expand the scope of the ECT to cover new materials such as hydrogen. They also agreed to install a flexibility mechanism, which allows contracting parties to carve out fossil fuel investment. By the way, I'm talking about this agreement in principle based on leaked documents, which are publicly available. And according to the leaked document, the UK and the EU are about to use this flexibility mechanism to carve out fossil fuel investment, but Japan is not. The substantive protection of investment, there is clarification of some key obligations such as FET and so on. And there is a very explicit provision to reaffirm the contracting parties' right to regulate to achieve legitimate public policy objectives. And there is an extensive provision on sustainable development. And in terms of investor-state dispute settlement, the parties agreed to incorporate the ancestral rules on transparency, and there are new disciplines on the third-party funding. And most importantly, there's a provision to ensure that the ISDS provision of the ECT would not apply to interregional economic integration organization relations. In other words, the intention of the provision is to ensure that the ECT ISDS would not apply to intra-EU disputes. And also the European Commission proposes subsequent agreement on the non-applicability of the ECT ISDS to inter-EU relations. So I think we can say that the agreement in principle successfully addresses the EU's concern as to the applicability, the applicability of the ECT or non-applicability of the ECT ISDS to intra-EU disputes. And also in terms of climate change policy, I think we can say that the modernized version of the ECT, if agreed, would be one of the most climate-friendly investment agreement that have ever been agreed upon. I'm not saying this is a perfect agreement. Of course, there were discussions, negotiations, and so on. There have to be compromises. However, compared to the past investment agreements, this modernized version would be a very climate-friendly investment agreement. But anyway, many European countries criticize the modernization, the agreement in principle, saying that this is not enough. This is not sufficiently aligned with the Paris Agreement. And they announced their intention to withdraw from the ECT. And there's finger pointing at Japan, Japan is sort of, those countries are blaming Japan for the failure of the modernization. So I'll try to look at what is behind Japan's policy, Japan's attitude against the modernization, what sort of stopped Japan from agreeing to more advanced modernization of the ECT. So I'll first look at the energy policy perspectives. And in order to understand Japan's policy, you have to understand the very low and very difficult situation of Japan's energy supply. Japan's energy self-sufficiency rate is extremely low, the lowest among the G7 countries. It's 11.2%. And if you look at the sources of energy, Japan is very much dependent on fossil fuels. It's 84.8%. But I have to say that other G7 countries are highly dependent on fossil fuels at this moment. Let me focus on the nuclear power, because the Japanese government used to see nuclear power as a key to the transition to a carbon neutral society. But as you know, there was the great East Japan earthquake and the Fukushima nuclear power plant accident. And after the accident, all the nuclear power plants had to be shut down, and the government toughened the safety regulations, and all the nuclear power plants have to go through very tough safety tests. And even if the power plants pass those tests, they have to get consent from the local communities, and that's very complicated and very difficult to get consent from the local communities. Understandably, it's very difficult. And also, the percentage of renewable energy remains very, very limited. I can say that Japan has one of the largest solar power capacity, but Japan is very slow at introducing wind power, and that probably explains the limited percentage of renewable energy. So it's really very difficult situation. That Japan is in a very difficult situation. Japan can, although the current government is trying to increase the percentage of nuclear power, but they can't do it because of the opposition from the local communities against nuclear power. And although they try to increase the percentage of renewable energy, the industries are very slow at introducing renewable energy. And well, Japan periodically issues a strategic energy plan. The latest one was issued last year, and there are 4 pillars in the plan: safety, energy security, economic efficiency, and the environment. So it's not like Japan ignores the environment, but the environment is one of the 4 pillars. But I think I should say that the safety and the energy security are the core of Japan's energy plan. And there's a very acute sense of energy insecurity because of the geographical conditions. Japan is an island. Japan has very limited natural resources, and we had very difficult historical experiences like the oil crisis or the nuclear power plant accident. And also Japan has geopolitical and geoeconomic tensions with the neighboring countries. So these factors explain the sense of energy insecurity, and these factors probably explain Japan's position in the modernization process. I'm not justifying it, but this is a reality that Japan is facing. Let me move on to the legal policy perspectives. Well, if you look at the statistics of the ISDS cases, investment dispute cases, there are only 6 known treaty-based ISDS cases brought by Japanese investors, and 4 are under the ECT. And all the 4 cases under the ECT are concerned with renewable energy investment. It's not like fossil fuel investment and so on. And there's only 1 case brought against the Japanese government. And there's no case under the ECT that was brought against the Japanese government. So it's Japan doesn't have real experience of using ISDS or being sued by foreign investors. And there are consequences of this limited experience. There's a strong skepticism in Europe against the ISDS, but that skepticism resulted from the large number of ISDS cases against European countries. You just heard that 82 cases were brought against European countries, but we don't have that experience. That's why people don't really know about the ISDS in Japan. People don't care about the ISDS, and the industries are happy with the ISDS. Although the industries do not use ISDS so often, but they're happy that they have the possibility of using ISDS. And when the industries and when the public are happy with the ISDS, probably it's difficult for the Japanese government to change the policy. The Japanese government has been explaining to the industries, to the public, that it's good to have ISDS. It's good to have strong investment protection. And the government can't change its policy when the industries and the public are happy with that. So I would say Japan may not have strong reasons to oppose modernization, but Japan's do not have strong reasons to support modernization either. That probably explains the current Japan's position. But what lies ahead? Very briefly, as I said, several EU member states announced their intention to withdraw from the ECT. So Japan may have to explore some other possibilities. But the best case scenario for Japan is that the modernized ECT is adopted and ratified by the existing contracted parties and enters into force. Because as I said, the modernized ECT will be one of the most climate-friendly investment agreement. But I think this scenario is unlikely to happen, at least in the near future, or maybe in the distant future. So we have to think about different options. I wouldn't talk much about the other options, but I think Japan has to think about new approach to investment law. We have to think about other forms of investment dispute settlement. We probably don't need investment arbitration, but we have to think about using a multilateral investment court system, or instead of focusing on investment protection, we have to think about investment facilitation, or in short, perhaps Japan has to explore a new approach to international investment law. Well, that's all from me, and thank you very much for your attention.
Thank you very much, Professor Fukunaga, for that fascinating insight on where Japan is coming from in terms of the ECT modernization discussions. And well, I guess that's a story where we can only say we will see what happens based upon the deferral of a decision to April next year. I had thought when we were scheduling this that we would be at that point, be able to say, well, we now know the outcome of this process, but alas, not to be. Anatole Boot, Professor Boot, perhaps you can help us with some of that in talking about the ECT as a mechanism to protect clean investments. Please go ahead.
Can you see my slides?
Yes, I can. Thank you.
Okay, wonderful. Then thank you very much. My argument is very simple, and it is essentially that investment protection, including the ECT, has a positive role to play in facilitating decarbonization. So although I recognize the importance of modernizing the ECT, modernizing investment agreements in general to avoid the risk of regulatory chill and the existing, I think it's important to remove the existing obstacles that ISDS can create, for instance, for phase-out decisions. I also believe that investment agreements have an important role to play in de-risking clean energy investments, particularly in developing countries, particularly in Asia. Even. So let me use some examples from Asia, given the focus on this region. So the starting point, as already mentioned by Janssen, is that starting point of my analysis is that decarbonization is essentially an investment challenge. We need to transfer significant sums of money and technology to the energy sector in particular to decarbonize energy supply. We need trillions of US dollars to be redirected to clean energy sources, right? I think that's the key starting point. We need investments. Investments are at the center of decarbonization, low carbon investments. So this is, well, it has been clear from a very long time and has been again confirmed by the IPCC in its latest assessment report. Now, most investment needs are in, so the investment needs are greatest in developing countries. So the first dimension here is that governments alone cannot address the decarbonization challenge. They cannot provide the funds to transition towards decarbonization. We need private capital. We need, in developing countries, we need foreign investments. And particularly, as I said, as the IPCC says, particularly in low-income developing countries with large sovereign debt, that the government cannot provide this the financing needs required. So future investment needs are greatest in emerging and developing economies. And the problem, of course, is that these are also the countries that already face a higher cost of capital. And that higher cost of capital is hindering their capacity to finance a transition. So it's more expensive to invest in a wind farm in a country with a risky investment climate than in Europe, let's say, where you have, more predictability of the policies, of the regulations, but also you can rely on stronger courts. So all this is very simple, but I feel the need to emphasize all this because I believe it's an aspect that has been ignored from the discussion on ISDS and climate change mitigation. So a major challenge is, of course, that in low-income developing countries, many of these projects are not attractive for companies because they are risky. So they are unattractive risk-return profiles, particularly due to weak regulatory environments. And I think we can expand that and include weak institutional environments, so weak courts, weak administrative systems, etc. That's a major problem. Now, we don't have to look at Asia to understand that problem. Just look at Europe. And I mean, there's a lot of evidence on this. This has been repeated over and over by the industry. Now, of course, they are biased. They have a financial interest in that. But I think it's kind of common sense. And it's confirmed by the IPCC and by the Stern report and by the IMF and by all other official reports and by academic studies that predictability and stability is needed. And this is also something that Professor Paulson mentioned in his talk. You need predictability. This is at the center, for instance, of the European Renewable Energy Directive. Policies supporting renewable energy should be predictable and stable. Vice versa, policy unpredictability and instability have a direct impact on capital financing costs, on the costs of project development, and therefore on the overall cost of deploying renewable energy. Unpredictability, instability are not good. They make it more expensive to finance the energy transition. All right, so that's extremely important. I think stability and predictability are key concepts here. So here in the European Union law, I could say, or directive on renewable energy, member states are recommended not to, in fact required, not to change their policies too regularly, because particularly not if that affects the financial viability of investments. Another example, in an advanced and robust, relatively robust institutional environment, the UK, the House of Commons in 2016 criticized the government's actions reforming the renewable energy system by saying that it undermined the confidence needed by the industry to invest in the sector. So this is a developed environment, I should say, a more robust institutional context. That in this context, you can, through national law, through courts, through legal principles like legal certainty, legitimate expectations, etc., you can try to protect, or even the right to property, go to courts and try to enforce rights in case of regulatory changes. And this is also reinforced at the European Union level by a requirement now under the 2018 directive, a requirement of financial stability. Member states shall ensure that the level of and the conditions attached to the support granted to renewable energy projects are not revised in a way that negatively affects the rights conferred thereunder and undermines the economic viability of projects that already benefit from support. This is an obligation under European Union law from 2018. It comes in addition to the general principles of law, legal certainty, legitimate expectations, the protection of the right to property. Now, this is Europe. Let's now move to Asia. And I've written a book on energy security in Central Asia. I spent a lot of time there studying the electricity regulations and the renewable energy laws and policies in Central Asia. Now, I can tell you, the institutional environment there is very different. And of course, it's almost impossible, even if you have a robust or strong commitment of stability in your national law, it's of course very difficult to use national courts to enforce that commitment in case of regulatory changes, of course. So how to enforce that? You don't have that supranational EU guarantee, and you don't have the judicial system, at least not the same type of protection of independence as you have, of course, in advanced or more well, let's say, robust administrative institutional systems. And the World Bank confirms that, and well, my analysis shows that it's of course more difficult here in this more unstable institutional environment to create a legal environment, a regulatory environment that is attractive to investors. And even if you manage to create this, how can you enforce it? And so there are many examples of electricity market reforms in Central Asia that have failed simply because of insufficient institutional protection. So the IPCC emphasizes the importance of credible signaling by governments and the role this plays in reducing transition risks. And so the question is, what options are there? How can we de-risk low carbon investments? Well, they recommend using public finance, also transferring finance from developed to developing countries. And they also emphasize the role of public guarantees to reduce risks and leverage private flows at a lower cost. But of course, this has public guarantees have an impact on credit rating, and governments don't like to give public guarantees because this affects well, so it's not something that they are extremely keen to do. and this particularly in low-income developing countries with large sovereign debt or debt already. So what about international investment law? Well, according to the IPCC and according to, I would say, the majority of academic views, international investment agreements are an obstacle to decarbonization. They are constraining the latitude of host countries in adopting environmental policies, in adopting climate policies. So a very active debate now that makes that point very clearly. It's now absolutely crystal clear. ISDS is something bad. Indeed, it can potentially constrain phase-out decisions. We've seen it, Rockhopper, RWE, etc. There are indeed, I'm not denying this, absolutely clear, that there is clearly a risk that ISDS can be used against these decisions. So that's a fact, and I'm absolutely not denying this. However, what I believe is missing in the debate is the role that international investment agreements, ISDS, can play in de-risking investment law. Isn't ISDS, as explained by Dawson and Schroer, and I think everyone would agree, aren't investment treaties aimed at addressing the risks that long-term investment projects face? Aren't they about providing stability and predictability in the sense of an investment-friendly climate? Now, I'm aware of the problems this creates for states' regulatory sovereignty. I'm aware of the constraints this creates on them and the implications regarding the protection of fossil investments. At the same time, I think it would be a mistake to ignore the potential contribution that this mechanism can play in de-risking clean energy investments. So the Energy Charter Treaty, for instance, has clear provisions aiming to create stable and transparent conditions for investors. And we've seen that investors have made use of that, particularly against Spain, the Czech Republic, Italy, etc., where they've tried to enforce their rights in the European Union. And this has, of course, resulted in significant criticism by the European Union states, resulting, as explained before, in a decision to withdraw from the ECT. I believe this is potentially a problem because the countries in Central Asia, for instance, need European capital, need international financing to facilitate their decarbonization process. They need European investments. Now, these European private companies, foreign companies, will no longer be able to rely on protection under the Energy Charter Treaty when funding these wind farms, these solar farms, these clean energy projects that are needed to decarbonize as urgently as possible the Central Asian energy sector. And this is just an example. Of course, this applies to all other countries in the region. Central Asian countries are, of course, very important because they have a significant potential for renewable energy, a very risky investment climate, and they're all members of the Energy Charter Treaty. So by withdrawing from the ECT, the European countries are actually withdrawing the protection that their companies could benefit when contributing to the decarbonization of the Central Asian energy sector. So in my view, that's a problem. That issue, in my view, at least I've missed it in the debate. I think it's very important to realize that this might not be a good thing for climate change if, particularly in those countries where most investment needs, those countries characterized with the largest investment needs in terms of low carbon technologies and lowest, highest sovereign debt, the riskiest investment conditions. These countries, particularly there, they require, in my view, this additional level of protection to attract, to enable the financing of projects to plug this financing gap. So reform is needed. Reform of ISDS, reform of investment agreements is needed. I fully support this. Reform of the ECT is absolutely essential to avoid the problems we've seen in the fossil fuel sector. I fully support this conclusion. I do, however, not support the idea of withdrawing from the ECT. I think On the contrary, we need clearer standards of protection for low carbon investors. And of course, also, yes, delimitate clearly the sovereign rights of states, their need for flexibility in adjusting their policies and regulations to reflect changes in costs and technological developments. But at the same time, the industry needs predictability. And I think the ECT, and I'm using here a concept by Kai Aubert, on the ECT jurisprudence, you have that level of additional predictability because all the decisions that have been taken on one particular technology, solar or energy, and based on similar sets of laws. So we know more or less, at least more predictably, how these principles will be applied in the clean energy sector. And we can make some conclusions as to what works, what doesn't work, what requires adjustment. That's totally missing from the ECT modernization debate, and I think that's a missed opportunity. So to conclude my relatively simple argument, and I'm sure could be found perhaps a little bit controversial, I believe ISDS, investment arbitration, investment treaties have a role to play in de-risking low carbon investments, particularly in developing countries, characterized with the largest investment gap and the highest level of sovereign debt. We need more predictable standards of protection, these to attract, to reassure investors, but also, of course, to protect and safeguard states' regulatory space. Thank you very much. I've written several papers on this, so feel free to have a look and, of course, to criticize my views. Happy, of course, to hear a criticism. Thank you very much.
Thank you very much, Anatole, for sharing those views and for raising, yes, I think probably what for many, certainly academics in the investment treaty world would be considered a controversial position. But nevertheless, I think there's probably a general agreement, as we heard already from Lauga and from others, that stability and predictability in regulatory regimes is of key importance for investment decision making. And perhaps the question really then is, what is the best way to achieve that? And I think you've raised a provocative argument that the ECT can still serve that role. I want to turn now to Professor Ying Zhu, who is at Hong Kong University and who will talk to us about the role of China in investment treaty making, both its own policy and perhaps the role that it might play more broadly, globally and regionally. So, Professor Zhu, over to you.
Thank you so much, Palamita. Thank you so much.
Just to let you know, we can see your slides, but you're not in. There you go. Now you're in slide mode. Yep.
Okay. Okay. Thank you so much for your invitation, Professor Calamita. So my presentation is about Chinese investment treaties and climate change. I will first broadly introduce the relationship between investment treaties and climate change. Then I will focus on China, why China has a mixed position in investment protection and climate actions, and how those positions affect Chinese actions. And then I will take an empirical review of Chinese investment treaties and to study its climate implications. Then I will introduce a special challenge faced by China, that is how to balance liberalization and sustainability, which I think is a major challenge also for many developing countries. At this point, I think China is a special case. It's different from EU and it's different from the US. And in this respect, China can be a leader for the Asia and the world on how to sustainabilize investment treaties amid the liberalization way. Finally, I will draw a conclusion. Investment treaties and climate change are not enemies to each other, which I think Professor Boot has explained it quite well. So now the scholarship mainly focus on how investment treaties can chill the climate regulatory space. The UNCTAD report has collected several cases, actually many of them, on how investment treaties may cause ISDS cases that chill the climate actions by host states. You can see it's not only those renewable energy cases faced mainly by Europe, but also there are many fossil fuel cases which are thought by UNCTAD that is related to the climate protection. And this problem has drawn wide attention, not only in law discipline. So this year, the Science Journal has published an article on how investment state disputes threaten the global green energy transition. But on the other hand, investment treaties can also be a tool to promote climate investment. As Professor Boot has just explained, the IPCC has seen this opportunity, but it didn't place investment treaties at a core tool to promote climate investment. IPCC has regarded climate investment as very important, and compared with mitigation, the adaptation efforts need more investment. So China is a special case here. China has a mixed position on climate change and also on investment treaties. First, China has multiple and sometimes conflicting national interests. We know that China is both a main capital exporting country and also a capital importing country. So as a capital exporting country, China has a large amounts of overseas investments, including both polluting investment and also clean investment. Actually, China is the major country of clean energy exports. And also China, as a capital importing country, also has a very complicated and mixed interest. First, China needs foreign investment to develop its economics. But on the other hand, China is developing towards ecological civilization and carbon neutrality. China has promised to reach the peak carbon by 2030 and to reach carbon neutrality by 2060. So it really needs regulatory space for climate actions. These positions cause China's conflicting interest. On the one hand, it needs to protect investment. On the other hand, it needs to preserve the regulatory space. Also, if we take a broader view of China's role in the world, we can see that Chinese actions is not very clear now, because China faces conflicting attitudes towards what its role should be in this changing world. China is rising, but on the one hand, it wants to play a leading role in global governance, both including the foreign investments and also including the climate change cooperations. But on the other hand, China is facing fierce tensions from other countries on whether Chinese rise is a threat to other countries. We can see the US-China trade war and technology war, etc. So this caused China's mixed positions in its diplomacy. The third aspect of Chinese mixed position is that it is taking domestic reform amid international reform. So from a domestic perspective, China is currently taking the policy of deepen reform and opening up, which means that it wants to open up its door wider to attract more foreign investment. We see in 2019, China enacted its new foreign investment law, and in 2021, China enacted its new Hainan Free Trade Port Law, which is the first law on the free trade zone in China. But on the other hand, China is also preparing a toolbox for lawfare and its national security. So this part is also developing very fast amid the opening up policy. So in 2020, China enacted its measures for the security review of foreign investment, which established the National Security Review of Foreign Investment in China. And later on, it enacted a list of regulations to protect national security and to deal with the international sanctions, including the unreliable entity list, the export control law, the blocking statutes, the anti-foreign sanctions law. And this mixed position also reflects in its international actions. On the one hand, China is including more FTAs and BITs to broaden its investment protection efforts, including RCEP, CAI with Europe, and it also show its positive attitude to join the CPTPP, though I think it is of little opportunity in practice. And also, we can see China is acting actively in the reform of investment treaties and the ISDS regime to protect the regulatory space, which is a little bit conflict to its liberalization attitude of foreign investment attraction. So recent Chinese bids and FTAs reflect the global trend of regulatory space protection. It clarified its standards of protection, including the general exceptions clauses to the recently concluded treaties. But those efforts are in diverse approaches. In some treaties, China adopted the European approach. In other treaties, China adopted the US approach. So it does not have a very clear methodology of reforming the investment treaties. And we can also see Chinese active role in the ISDS reform. So those mixed positions explain the Chinese complicated actions in the field of both investment laws and climate change laws and policies. So what is the current status of Chinese investment treaties? China actually has a very large body of investment treaties, including 145 bilateral investment treaties and 25 treaties with investment provisions, mainly FTAs. Those treaties are like the treaties in other countries. They have standards of protection and also provides investor-state dispute settlement. Chinese cases in ISDS mechanism are also rising. So as of now, China has acted as respondent state for 9 times since 2011. And the 4 cases were after 2020. And China was the home state of claimant for 13 times since 2007, and 6 of them are after 2020. So you can see the cases are rapidly rising. So China take a very serious attitude towards the investment treaty regime and also the ISDS mechanism. So in those cases, China hasn't lost a case as a respondent state. An interesting case is Asia versus China in 2020. The case is still pending. The case is about one province of China called Sichuan province enacted a national park for panda. But by initiating of this park, it needs to expropriate the mining projects. And one mining project is operated by the Singaporean investors. So the Singaporean investors claim that the building of the giant panda park and by which expropriation of its property has constituted indirect expropriation. So from this case, you can see that China has a position not only as a capital exporting country, but also as a capital importing country. It needs to protect its environmental regulatory space. So this is an overview of Chinese investment treaties. From this table, you can see that most of the treaties are concluded before 2000. So most of them are old traditional investment treaties. Chinese treaties include 4 generations. The first generation is in 1980s, when China first opened up its door to the world. And at that time, the treaties are very conservative. It has balanced preambles that acknowledge not only the protection of investment, but also the mutual benefits and prosperity of states. And it also has very limited scope of protection of foreign investments, both substantially and procedurally. For example, there were no national treatment clauses in those treaties. And the free transfer of funds and FET clauses are subject to domestic laws and regulations. And also procedurally, it only allows dispute concerning the amount of compensation for expropriation to international arbitration. And it has not acceded to exit at that time, so it was subject to ad hoc arbitration tribunals. And even in those early stages, China has some early forms of public interest exceptions clauses. For example, in 1983, China-Germany bids. It was the very second Chinese bid. It provided that the measures adopted by the whole state for public safety and order, public health, or morality are not considered to be discriminatory. This exception remains in the 2003 amended China-Germany bid. The second generation of Chinese bids are in 1990s. It generally follows the first generation. It also have very balanced preambles, stressing not only the protection for investments, but also the protection of sovereignty, equality, and the mutual benefits of both states. And also there were a small portion of bids that expand protection to foreign investment by adding national treatment and umbrella clauses. But those treaties are in a very conservative way, which means that it have conditions that the protection is subject to domestic law, or it have very soft language. It says that national treatment should be accorded to the extent possible. And also there were a few bids adopt exceptions clauses to preserve public interest of the whole state. So in 2000, there comes the third generation of Chinese bids. It also have very balanced preambles, stressing the interest of both investors and states. And some treaties started to acknowledge the right to regulate and the public interest. At that time, the treaties started to be more liberalized. They provide further expansion of the scope of standards of protection. Most of them have national treatment clauses, and some of them have clarified standards of protection. For example, some treaties clarify what is indirect expropriation, and other treaties clarify what is fair and equitable treatment. And some other investment treaties have exceptions clauses for public order or the corporate social responsibility measures. In 2010s, there were the fourth generation of Chinese investment treaties. They have balanced preambles incorporating the concepts of sustainable development and or the corporate social responsibilities. And those treaties more often clarify the standards of protection. And some of them include general exception clauses as an exception to the investment protection clauses. And in 2020s, we see China concluded more FTAs. For example, RCEP and CAI. They have balanced preambles. They have clarified and non-qualified standards of protection. And they have general exceptions clauses for public interest protection. And also they include soft commitments, for example, the no lowering standard clauses, or the corporate social responsibilities clauses, and the promotion of green investment clauses, and the climate change clauses. So this is an example of CAI, which is now in the final concluding process between China and Europe. The Article 6 says that the contracting parties recognize the importance of implementation of the UNFCCC and the pursuit of the goals of the Paris Agreement. And it uses the strong word shall. Each party shall effectively implement their obligations and also promote and facilitate investment of relevance for climate change mitigation and adaptation. And they should cooperate with other parties on investment-related aspects of climate change policies and measures. And the final word is a little bit soft. It says as appropriate. So if we go through the 4 stages of Chinese investment treaties, we can say that Chinese investment treaties are going through a different path from other major capital exporting countries, including EU and the US. So China, as of now, most Chinese investment treaties are still very conservative. So if China wants to reform its treaties, it needs to both liberalize the treaties and also it needs to sustainabilize its treaties to protect the appropriate right to regulate. If we regard the current reform of investment treaties as the approach of how to protect the right to regulate, actually most Chinese treaties as of now are quite advanced because many of them are very conservative. But I think that is not the point of today. We need not only to protect the right to regulate, but we need to figure out what kind of right to regulate we are protecting. So for China, I think there is a different greening method. For US or EU, they have already very liberal investment protection standards in their investment treaties. So their focus should be how to clarify the standards of protection or how to carve out the regulatory space for public interest protection. But for China, most treaties of China are still very conservative. So China is facing what I call is sustainable liberalization approach. So you can see from this chart, for US and EU, the original standards of protection are quite broad. So they either need to clarify the standards of protection to shrink its protection scope, or they need to carve out some regulatory space by, for example, the general exceptions clauses to allow more sovereign right to regulate. But for China, most of these treaties are like this. So it has very limited investment protection, which means the states, the whole states, have very large regulatory space. So what's the next step for China? I think this is a special challenge for China, and also it can be a special challenge for many developing countries. As a conclusion, first, I think the mixed position of China explains its complex practice in both FDI and climate change laws and policies. And also with this mixed position, China has a more potentiality and incentive to balance investment protection and climate actions, because China has a dual role of both capital exporting and capital importing country. And it has large amounts of overseas investment. And on the other hand, it needs to attract investment inland. China both need to protect its overseas clean investment, and also it needs to protect the regulatory space for its domestic environmental protection and carbon neutrality efforts. So this is why I think China can be a leader of the sustainable liberalization approach, which may be a good way for many developing countries to modernize their investment treaties. And its implications for Asia and the world is that when we think about how far we should go to protect the right to regulate of host states, maybe we should think what kind of regulatory space we are protecting. Should we go back to the Carver's doctrine to protect all the regulatory rights of the states and to limit the protection of investors, like the old Chinese investment treaties are? Or should we promote sustainable investment and modernize those investments to be suitable for sustainable investment? Okay, so that's all of my presentation. Thank you so much.
Thanks very much, Dr. Zhu. I confess, in listening to some of the presentations today, I can't help but think that very often how one assesses the need for reform and the risk of claims very much depends upon where you're sitting and whether or not you've actually been sued and lost a big case or had one of those near-death experiences like the United States did in the Methanex case. And it strikes me that particularly with respect to China, China's experience as a defendant is actually quite limited. And China, I'm not quite as sanguine, I suppose, as you are with respect to the limited scope of protection that you see in some of those older Chinese treaties. I think there's a chance that in the right case, one might find that those treaties provide a greater degree of protection. But that's just a question. Maybe we pick it up in our discussion. And certainly, you know a great deal more about China's investment treaties than I do. But it's fascinating. And I am fascinated to hear, Professor Swarnaraja, what you make of all of this and our discussion today. I gave you the title "Fiddling While Rome Burns." Perhaps that was unfair, or was that accurate?
Well, you know, I am sort of committed to the title, which Jansen has given, that we are fiddling while Rome burns. I think that it's not Rome alone that's burning. The whole world is burning. You know, you have fires in California, in Sydney, and other places which are attributed to climate change. Besides that, we have floods in Pakistan, droughts in many parts of Africa, again attributed to issues of climate change. So there is a world that faces an amazing amount of catastrophic factors which have been predicted by scientists. So in that context, then, what we are sort of talking about is of little relevance. The protection of foreign investments. I think that should be the least of the problems that confront the world or confront an international lawyer at the moment. The fact is that there are so many investment treaties and so many claims are brought against poor states like Pakistan, which face environmental problems. So just before Pakistan had its floods, there was this investment treaty arbitration, Tetian versus Pakistan, in which Pakistan was asked to pay damages amounting to $6 billion, something that is fascinating in the context of a country that whose budget, annual budget doesn't exceed that sum of money and is faced with so much of problems like floods and famines that attend it. So in that context, then, what we are discussing, you know, the protection of investments has low priority. And what has not been discussed is whether these treaties should continue to exist at all. Interestingly, the OECD's study is headed Future of Investment Treaties. So it sort of automatically assumes that investment treaties do have a future and that they should continue. And what we are doing is having these treaties laundered through institutions like the OECD and UNCITRAL or some other international association that is somewhat prejudiced towards the acceptance of these treaties. And we also find presentations that are made by much younger scholars than me, who obviously wise too, who want to see the treaty systems continue and speak in terms of the continuance of this system with some improvements. As I see the problem, none of the improvements, so-called improvements that have been made, have had any effect in bringing about changes to the system. We saw the introduction of sustainability, and we were told that the idea of sustainable development is going to change the picture and that a new type of treaty is going to come into existence. But it did not happen. The arbitrators went the same old way and gave as much protection as possible to foreign investments. Then we have the so-called balanced treaties that are coming into currency now. We see the Chinese making treaties which are balanced treaties that have so many different types of defenses that are mentioned. And the only case in which balanced treaty has been interpreted so far has been the Eco-Oro Colombia case, in which we saw that despite the existence of a defense relating to the protection of the environment, there was liability. There was an award based on liability for Colombia for the measures that it had taken in order to prevent the mining contract subject to the dispute there affecting the environment of a very sensitive area of the world. So it would appear that these improvements that have come to be made and have been spoken about have had little consequence at all. The idea that there should be defenses based on environment, that in itself seems rather atrocious, because one would think that a world that is faced with calamity should have the right to ensure that every state that is affected by climate change takes sufficient measures to protect its people from the consequences of climate change. That should be, after all, a right that vests in a state, and that right ensures that violations of treaty obligations under investment treaties or any other treaties must be subject to that prior right that a state has. We are told that the safety of the people is the supreme law. Salus populi, suprema lex. I think Cicero or somebody did say it. I think so. In that context, then one must ensure that that climate change has a greater priority than investment protection under investment treaties, which are of different types. As in China, and that's what's explained, the early Chinese treaties created very few obligations. You could have ISDS only in respect of a limited subject, the amount of compensation that was payable. So this fiction that investment flows do not take place if you don't have investment treaties is not a maintainable fiction. We have had investment treaties for 70 odd years, but there's nothing to show that economic development has taken place in the world as a result of these treaties. What we now have is that the consequences of climate change are being transferred to the poorer states. So studies like a recent study at the Bartlett Center on construction management of the University College in London and Tianjin University. They show that the existence of global value change means that multinationals are transferring their production to poorer countries, ensuring that the poorer countries are the location for climate change. So once again, we have a repetition of the North-South position where the poorer black, yellow, and white, black, yellow, and brown people have to meet the consequences of climate change. Unjust situation that comes about as a result of investment treaties, because these transfers that are affected by global value changes are protected by investment treaties. So I would say that we must regard climate change as a changed circumstance in terms of international law, which devalues completely the obligations under investment treaties. So to be consistent with the Vienna Convention on the Law of Treaties, one could argue then that climate change and particularly the obligations under the Paris Agreement are such changes that have taken place in international law that they displace the obligations under bilateral investment treaties. After all, we are here talking of bilateral treaties, which are of different types. The hoary idea that they constitute customary international law is just a load of bunkum, because each investment treaty is so different from the other. I mean, you were told about the Chinese practice. There were 4 different eras in which treaties were made, and the Chinese treaties are not like each other at all. They were differently negotiated. So there's nothing customary about the obligations that come about by way of these treaties. So the climate change constitutes the most important change circumstance that has taken place in recent times. And also one must argue that the consequences of climate change are so important from the point of view of the world that there is a jus cogens principle that arises that the law on climate change must have utmost precedence over other international law. So on that basis too, I would suggest that we discard investment treaties and their relevance to disputes that involve climate change. So I confine myself, at least for the moment, to disputes that relate to climate change. And I would say that that in the context of climate change, investment treaties should not have any role to play. So once it is determined that the dispute involves climate change, that should be the end of the situation, and that there should not be any further inquiry by any tribunal into the matter. So even if there is an inquiry by an investment tribunal, what would the logical consequences of it be? Provided there is an unbiased tribunal, and that in my view, is also a contentious problem, because arbitration tribunals have massive biases, as the Eco Colombia situation showed. I mean, in Eco and Colombia, there was a very extensive survey done by the local courts of Colombia, which are reproduced in the award itself, and a comparison with the reasoning of the local courts and the reasoning of the tribunal shows the difference in quality of the considerations of the local Colombian courts and those of the majority of the tribunal in that award. So my view is that even if you take the treaty honestly into account, there's no way that you could give an award favorable to an investor in a situation of a dispute involving a measure preventing climate change. There wouldn't be any discrimination because of the fact that the investor would have been found to have violated climate change laws. There wouldn't be protection under fair and equitable treatment, simply because such an investor could not have a legitimate expectation as to non-interference. It would clearly be a regulatory expropriation because it is threatening a vital interest of the state. So I would say that in these situations, there should be a jurisdictional defense that the tribunal should not go further once it is found that the dispute involves measures relating to climate change. But the problem simply is that the investment arbitration system under investment treaties has become so tenacious that such arguments will not be met, because, you know, law firms make huge sums of money. Arbitrators have a very lucrative profession. Why would they want to accept arguments of this sort? So we have a law that is made in order to promote sheer greed of a limited number of people, trouncing the legitimate interests of the poorer sections of humanity. And that's the tragedy of it. So when you talk in terms of just the energy situation, like say, for example, in the case of Japan or in the case of the Central European countries, the idea that you should take a soft stance because of energy insecurity, that seems to me to be a bit of a weak argument, because here we suffer the consequences of climate change as a part of humanity rather than as a part of a country. So as far as Japan is concerned, you know, I mean, it is true that the Japanese would have an interest in investment treaties because, as first pointed out, there were 6 cases which Japanese foreign investors brought against Japan. Japanese foreign investors bought against host countries. But I think there's little reference made to a case called the Halley case, in which proceedings were brought under the Energy Charter Treaty against Japan. And it's very difficult to find out any information about this case. Transparency, of course, doesn't matter because there's a lot of secrecy surrounding the real facts of this case. The Japanese government not releasing information about this particular case that was brought by a Hong Kong company relating to under the Energy Charter Treaty against Japan. And there's also the fact that the Japan-Philippines Treaty does not contain an ISDS provision, or at least at the time the treaty was negotiated, it did not have an ISDS provision. And at that time, there was considerable discussion in Japan and elsewhere as to whether it was appropriate to leave the ISDS provision out. So there are concerns about ISDS even within Japan. And as regards the protection of incoming clean investments, investments that seek to establish clean energy in developing countries, that's a bit of a paradox. It's an argument that cannot be tested. I mean, is it true to say that more investments would come in because stability is assured? I mean, on that economists differ to a significant extent. So I must say, what are the options that we have? I think I would say that we should get rid of law firms from this area altogether, that the matter should be argued by dedicated government lawyers who alone would have the power to appear before arbitration tribunals, and that arbitrators must have a deep knowledge of public and national law. I think I should stop here because my time is running out. Thank you so very much. Thank you.
Thanks so much, Professor Sonaraja. And thanks so much to all of our speakers. As usual, we scheduled this seminar for 2 hours, and we could have or should have scheduled it for 2.5 or 3 because of the issues raised and the very diverging, I think it's fair to say, perspectives of our various speakers. I wonder, one question, if I may raise, and this comes off of as well a question raised in the chat. During the COVID crisis, there was a suggestion by Jeffrey Sachs and others that there should be an ISDS moratorium with respect to claims that were based upon measures taken in response to the COVID crisis. That did not, of course, transpire. South Africa pushed in the WTO for the possibility of a TRIPS waiver. The reason I bring these up is that in these instances, these were potentials for multilateral reforms or multilateral solutions to address a pressing issue, and presumably to do so in a swift way, or a way that would be swifter and clearer than perhaps trying to revise the entire investment treaty regime and untangle the spaghetti bowl. Now, I appreciate that we've heard different views here with respect to the utility of investment protection for stimulating growth in investment, and particularly investment directed towards climate change mitigation and adaptation. But if one of the concerns is, generally speaking, for investors, that there should not be uncertainty, and if one of our concerns as citizens and scholars is that reforms cannot wait, is there an argument to be made here that a flat multilateral approach, which would, perhaps piggybacking on the kinds of arguments that Prof. Sorna has made, be appropriate in this circumstance, or at least until we can figure out and negotiate the more nuanced responses that perhaps are worth considering. Let me throw that out to all of our speakers. Perhaps to Lauga, I don't know if you were on the receiving end of one of those junior scholars greenwashing the regime to keep it going, but I mean, how are we going to do this? The OECD's had great success in multilateral reform of double taxation treaties, but do we have the time to come to those kinds of reforms if the issue is?
Yeah, so thanks, Jansen, and thanks also to the other excellent speakers. As chair, obviously, I can't take a position on what government should do or how they should do it, but I think the observation that to the extent there is a perceived need to reform or address the regime in whatever way we can sort of imagine, and that need comes from a concern about climate change, well, then indeed, the response would have to be swift, it would have to be clean, it would have to be associated with a degree of certainty that it's actually going to have an impact. And as I mentioned, this is one of the things we've been discussing over the last year. There's a whole range of possible things one could do. There's a whole range of theories about what might work in terms of clarifying objective standards like fide, or thinking about various forms of carve-outs. But to the extent that those sorts of responses are associated with considerable uncertainty, well, then that becomes a challenge in a climate context where measures have to be, or reforms have to be, have a significant impact and do so swiftly. So in that context, I think those sorts of challenges that's not just put forward by you, but also by Sorna, are indeed very appropriate. So we have to think very carefully about what is actually going to provide the biggest bang for the climate buck, not just in the long term, but also in the short term. And where do we have a degree of certainty that it's going to work? And the second thing I want to note, if I may, is I think one of the implications of thinking of the investment treaty from a climate perspective, particular when we have interventions dealing with policy space or regulatory chill or however you want to phrase it, is to think about not just what does the climate challenge imply for you as a government, as a host state, but also as a home state. We've had various interventions from capital exporting states that also receive significant amount of capital inflows. And the initial response, I think, that sort of the intuitive response, I think, in this regime, when we think about reform, is to think about it from the perspective of the policy space types of argument, where you're thinking as a host state, protecting your regulatory autonomy. But the logic of 2.1c in the Paris Agreement is also about your role as a home state in terms of the sorts of incentives you put in place abroad, because the logic that comes from 2.1c is that if you are supporting or facilitating or providing any sort of incentives for investments abroad that are associated with emissions, well, then you own those emissions, conceptually speaking. So I think the climate challenge for the investment treaty regime is to think not just in our capacity of host states, but also in our capacity of home states. What are the sorts of incentives we're putting in place abroad? Next.
Still muted. Thanks a lot, Lauga. And of course, we're already over time, but let me, if I may, turn to each of our other speakers in again the order that we spoke. So Professor Fukunaga next, and then Anatole, Prof. Zhu, and I'll give Prof. Sorna the last word, either on this this idea or this possibility of some kind of clean sweep moratorium, which I confess I put forward for academic discussion purposes and not as a policy view that I take personally, but or any other of the issues that have been raised today. And please, if you can limit your remarks to a minute, that would be fantastic. Thank you.
Thank you. Very briefly about the idea of moratorium. I'm inclined to agree to the idea, but I think it will be very difficult to agree on the scope of the moratorium and the duration of it. And also, if I may respond to what Professor Soranaja said, I think it's premature to assess the real impact of the so-called balanced investment treaties. And there is one case that didn't produce an expected result, but there may be more cases to come, and we have to wait for more cases to make an assessment of the balanced treaties. And as much as the substance of investment agreements is important, the way to implement it, the way to enforce them is also important. So maybe the ISDS investment obligation is not the best way to enforce treaties, but by having a different way of enforcing treaties, we can have a better result in favor of climate change policy. That's all from me. Thank you.
Thanks a lot. Anatole, why don't I turn it to you, please?
Thank you very much. So yes, I would be absolutely in favor of a moratorium on the protection of fossil fuel investments. And I think I agree with the idea that any investment dispute that involves a fossil investment should be dealt with very, very carefully, as proposed by Professor Sonaraja. I fully share the concern and the urgency to limit protection. I think it's disappointing that the modernization of the ECT didn't go further in excluding or limiting protection for fossil investments. I think it's disappointing that the modernization of the ECT didn't deal with the great importance of damages calculation for investments in the fossil fuel sector to avoid the kind of problems, huge injustice mentioned by Professor Sonaraja in the case of Pakistan. At the same time, I do believe it's worth looking at the protection of clean investments. I of course understand that there isn't a conclusive scientific economic evidence on the linking between investment protection and how it attracts investments. But I do believe it's one of the options available. And when I look at the other alternatives, I'm not sure these are much better or much more efficient in achieving that objective. So I do believe there should be more attention on that particular potential. Yes, thank you.
Thanks so much, Anatole. Prof. Zhu, let me turn it to you.
I'm quite positive on the idea, but I think the core issue is that we should promote state cooperation. I think that's the problem for many issues relating to foreign investment and also climate actions. We see that in the ISDS reform, major countries have different positions. EU want to promote a multilateral investment court, US has a different idea, and China has a different idea, and Russia is against it. So state cooperation is not very easy in the investment treaties, and also state cooperation is not easy in climate change. We see there is a bottom-up trend to promote states to pledge to say their own pledges rather than to cooperate in the multilateral reform in an effective way. So I believe that the problem can be solved in the future, in the long run, and I think the key here is how should we get state cooperation.
Thank you very much, Professor Zhu. Prof. Sorna, let me go back to you and let me phrase ask if you might phrase your remarks in connection with a question put by one of your former students in the chat, which asks, how much of what you envision do you think will realistically actually come to fruition in the near future? And is there at least some low-hanging fruit that we can pluck? Sorry, you're muted.
Well, it has been a long journey for me, and much of what I have said have not come about. So I don't see so too much of hope for the eventual fruition of my idea. But I think this moratorium is just a band-aid solution. It just doesn't work. The problem simply is that this whole system has to be changed. And this is an opportune time for its change, because there is a larger interest in climate change prevention, confronting with a very hierarchically smaller interest, the protection of multinational investment. So in that context, I think one hopes that there would be a greater change taking place than just the tinkering with existing investment treaties at the peripheries. Thank you.
Thank you, one and all, and thank you especially to our speakers for staying over some minutes. Let me thank Professor Paulson, Professor Fukunaga, Professor Boot, Professor Zhu, and my dear colleague, Professor Sornaraja, for all of your interventions and for, I think, getting this seminar series off to a very, very fine start indeed with these presentations and this discussion. Let me thank as well our audience for your participation, for your attendance. And let me invite you, please, to visit the CIL website, where you can stay up to date on what our next seminars will be, when they'll be, and who will be speaking. And Raela has just put that link in the chat. But as I say, we are currently scheduled for the 17th of January, where we'll be looking at the question of compensation and valuation in climate change claims under investment treaties. And let me just finally conclude by thanking all of my colleagues here at CIL who have worked very hard to put this seminar on today and have done a wonderful job, if I may say so. So thanks very much indeed. We will see you next time. Take care.